just bear with me 1 minute, please. Okay, I'm just going to hand over to the examining authority now. Thank you.
Thank you, Mrs. Church. Good morning, everybody, and welcome. It is Tuesday, the 16th of June. The time is now 10 o'clock, and session 1 of this first compulsory acquisition hearing is now open. My name is Gavin Jones, and I'm the lead member of the panel of examining inspectors appointed by the Secretary of State for the application made by Highways England for an order granting development consent for the M25 Junction 10 A3 Wisley interchange project. I shall now let the other panel member introduce himself.
Good morning, everybody. My name's Graham Gould, and as Mr. Jones indicated, I'm the other panel member. I am also going to make an announcement at this point. While we would ask that most people keep your phones off, i.e. those that you're not using to communicate with this conference, I'm having to keep all of my phones on at the moment because I have some personal circumstances, which means various family members need to contact me. Therefore, if my phone, one of them goes off, we may have to adjourn while I take whatever call that is. Thank you, Mr. Jones.
Thank you, Mr. Gould. As the examining authority, Mr. Gould and I are holding an examination into this application, and we will then write a report to the Secretary of State with our recommendation on whether or not consent should be given. Also present today from the Planning Inspectorate, and you've probably met some of them already, are Ms. Eleanor Church, Mr. CAH1, Ms. Candice Patton, and Mr. Richard Price. I think special mention today needs to go to Mr. Price, who has the unenviable task of sharing on screen the various plans and documents. And just whilst we're talking about screen sharing, I'm going to have a very quick go now at sharing the agenda with you, just quickly, just to make sure that the screen sharing is working. So if you just bear with me 1 moment, I shall attempt to share today's agenda with you. Are you all able to see that agenda?
Yes.
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 Is that a reasonable size agenda?
Yes.
And can you see that okay?
Yes.
Okay,
Yes.
thank you very much. I should come out of the screen sharing now. I just wanted to check it worked. Thank you very much. First of all, thank you all for attending today, and thank you all for your help in accommodating the additional steps that have been required in the build-up to this hearing. These aren't normal circumstances, as I'm sure you're all aware. Current government advice prevents the Planning Inspectorate from holding hearings as public gatherings are restricted. Those restrictions and our consideration of representations provided to us led to our decision to use Microsoft Teams to enable access to this virtual hearing by computer or tablet connected to the internet or by telephone. I don't think we've got anybody joining us by telephone for this session, but obviously if somebody drops out because their internet connection drops out, then they might need to rejoin via telephone. So I will talk about telephone as well, even though I don't think we've got anybody using that at the moment. I suspect that a virtual event is a new experience for most of us. And over the course of the next 3 days, there is every chance that sometimes the screen will freeze or internet connections may drop out, or that it may take us a while to locate and share the documents. Also, there is the chance that some of the documents may cause flickering on the screen. So please be aware of that if you are sensitive to flickering images. So taking all of this into account, we are unlikely to be able to proceed at the pace that we normally would in a normal face-to-face hearing. Therefore, Mr. Gould and I would ask for your patience as we all navigate our way through these hearing sessions. A recording is being made of this hearing. This will be the formal record of the hearing. If you participate in the hearing, you consent to being recorded. The recording is being made of both video and audio. If you do not wish to be videoed, then you can choose to switch off your camera using the toolbar on Teams. In addition, I understand the applicant will be running a live stream to other members of its team in the back office. To ensure compliance with the general data protection regulations, please try to avoid giving out any personal information of the sort that most people would prefer to keep private. Okay, I'm now going to turn to the introductions. Please ensure that your microphone is turned on when you are invited to speak. As I said, I don't think we've had anyone join us by telephone today, but if there is anyone on the telephone, then you need to press *6 on your keypad to switch your microphone on or off. When I call your name, please can you confirm that you are present and able to hear me clearly, and please indicate how you prefer to be addressed. If you're representing an organisation, please say what your role is. Okay, I shall start with the applicant, please.
Good morning, sir. I hope you can hear me. My name is Michael Humphreys. I am the advocate on behalf of the applicant, Highways England.
Thank you, Mr. Humphreys. Yes, I can hear you loud and clear. Next from the applicant's team, please, Mr. Chalice.
Good morning, sir. Mark Chalice from BDB Pitmans, acting for Highways England. I can see you clearly and hear you clearly.
Thank you, Mr. Chalice. I have Mr. Spencer.
Good morning, sir. Oliver Spencer from BDB Pitmans, solicitors for the applicant. I can both see and hear you clearly. Thank you.
Thank you. Mr. Wade.
Good morning, sir. Can hear you and see you very clearly. Thank you very much. I'm project manager for Highways England for this work.
Thank you very much, Mr. Wade. Ms. Watson.
Good morning, sir. I'm Jacqueline Watson. I work for Atkins, DCO advisor on behalf of the applicant. I can see and hear you clearly, and I'm happy to be referred to as Mrs. Watson. Thank you.
Thank you very much, Mrs. Watson. Mr. Barker, next from the applicant's team, please.
Good morning, sir. John Barker here from Atkins, representing Highways England. I am the strategic land lead on this project, and I can both hear you and see you well. Thank you.
Thank you very much, Mr. Barker. Ms. Blackham? Francesca Blackham?
Good morning, sir. Yes, Francesca Blackham from BDB Pitmans, solicitors for the applicant. And I can see and hear you very clearly. Thank you.
Thank you very much. Mr. Smith?
Good morning, sir. Graham Smith from the Valuation Office Agency representing Highways England. I can see and hear you fine. Thank you very much.
Thank you very much, Mr. Smith. And I have if I can read my own writing, Mr. Pugh.
Yeah, good morning, sir. Richard Pugh from the Valuation Office Agency advising Highways England. I can also see and hear you clearly. Thank you.
Thank you very much. I don't have anybody else on my list from Highways England. If there is anybody else from Highways England, please could you introduce yourself into the examination now? No, deafening silence means I think I've got you all, which is good. In which case I shall move next to Surrey County Council. I have Mr. Ty. Mr. Ty, Surrey County Council, you might need to turn your microphone on,
Yes,
Mr. Ty.
I can see you and hear you, sir.
Thank you very much. Next, I've got Ms. Jenkins. Judith Jenkins.
Yes, here. I can see and hear you perfectly.
Thank you very much. Mr. Stempfer.
Good morning, sir. My name's David Stempfer, Surrey County Council Major Projects Manager, coordinating the County Council's response, and I can hear and see you. Thank you.
Thank you, Mr. Stempfer. Mr. Mitchell.
Good morning, Steve Mitchell, Surrey County Council, Countryside Access Manager, and I can see and hear you clearly. Thanks.
Thank you very much, Mr. Mitchell. And Mr. Edwards.
Good morning, sir. My name is John Edwards from Surrey County Council. I'm the Natural Environment and Assessment Team Manager. I'm happy to be referred to as John or John Edwards, and I can hear and see you clearly. Thank you.
Okay, thank you very much. And then I have Ms. Forbes.
Morning, yes, Helen Forbes. I'm a solicitor with Surrey County Council. Happy to be called Helen Forbes, and I can see and hear you fine. Thanks.
Thank you. And I have Mr. Whitaker.
Yes, Benjamin Whitaker, Surrey County Council, and I can see and hear you clearly.
Thank you very much, Mr. Whitaker. That's all on my list from Surrey County Council. Is there anybody else?
No, sir.
Hello, please, can you introduce yourself?
David Stempfer, that's the Surrey team, sir.
Okay, thank you, Mr. Stempfer. Thank you, Mr. Stempfer. I was going to come on to it in a minute, but of course, because we're all in this virtual world, it's even more important than usual that you give your name when you speak, please, because I can only see so many faces on the screen and it becomes otherwise absolutely impossible to know who's saying what. So please, if we can get in the habit of giving our names when we speak, that would really be much appreciated. Thank you. It's even more.
Mr. Jones, sorry, it's Graham Gould. If I could just comment as well on the examining authority's behalf. Not only can you give your names, but can you also give your organisation when you introduce yourself, both for the benefit of the recording, but also for the benefit of everybody else. As Mr. Jones says, it's much more difficult in this environment to actually know who's saying what and who you represent, because we're not sitting around a table and can't plot that out in our own minds. Thank you.
Thank you very much, Mr. Gould. Yes. It's easier when you're sat in a room and you're all corralled into your various sections to know who's representing whom. But obviously in this online world, we've just got a number of pictures on the screen. OK, I don't have anybody from Paynes Hill Park Trust. I will put a shout out, but I don't think anybody checked in on Paynes Hill Park Trust. No, the silence means that's correct, in which case we move to Girl Guiding Greater London West. Ms. Donovan, please.
Hello, I'm Christine Donovan from Greater London West. I can hear you.
Thank you very much. And then I have Mr. Hill. Mr. Hill, you might need to turn your microphone on. Okay, it appears that Mr. Hill may have dropped out on us. In which case, hello, Mr. Hill. Okay, I'll move to your next colleague, Ms. Donovan, and then I might have to come back to you and just see if you're okay to continue without Mr. Hill's presence if we can't get him back. But I now have Ms. Wicks.
Yes, good morning. Christine Wicks from Girl Guiding Greater London West, and I can see and hear you clearly. Thank you.
Thank you very much. I presume that if we can't get Mr. Hill back, then Ms. Donovan, Ms. Wicks, you're okay to speak on behalf of GGLW today? Ms. Donovan, Ms. Wicks, are you okay to speak on behalf of GGLW today if we can't get Mr. Hill back?
He says that he's in at the moment. Sorry, it's Christine Donovan speaking, but yes, we'll speak on his behalf if we can't.
Okay, thank you very much. I think one of the case team's going to try and contact him now Thank you. In which case, I've got for Surrey Wildlife Trust, I've got Mr. Adler.
That's right, James Adler, Director of Biodiversity at Surrey Wildlife Trust. Happy to be called James Adler, and I can see and hear you clearly. Thank you.
Thank you very much, Mr. Adler. Next name on my list, I've got Mr. Max representing the RHS.
Good morning.
Your microphone went on and then went off again, Mr. Max.
Good morning, sir. My name is Richard Max from Richard Max & Co Solicitors. I can see and hear you clearly. I represent the RHS. I'm happy to be referred to as Richard Max or Richard.
Okay, thank you very much. And then the last name on my list is Mr. Cottage, also from the RHS. Hello, Mr. Cottage. Okay, if Mr. Cottage isn't there, Mr. Max, can I just revert to you? Am I okay to presume that you're able to speak to the on behalf of any matters pertaining to the RHS in this session in Mr. Cottage's absence if we can't get him back?
Yes, sir. Richard Max, Royal Horticultural Society. I can do that. He was online. Hopefully he'll join us as the meeting progresses.
Yeah, thank you very much. We might get some people, as I said in my introduction, we may well be getting some people dropping in and out today. It's the joys of the technology, I'm afraid, and this is precisely why we try to keep the numbers as limited as possible as well, because the more people we have, then the more chance there is of people dropping out, and it's just a harder event to manage if we have too many people.
Mr. Jones.
Yes, Mr. Gould.
Yeah, I just would comment generally. People just need to keep a watch on your mics. There is a little bit of a knack to switching on and off, and it might just be that those that have not been able to speak are just having some issues with their mics. So just be mindful that you can see it going on and off if the toolbar at the bottom of your screen is showing.
Thank you very much, Mr. Gould. I was actually going to come onto the microphones next. And since noises can be picked up quite easily with this technology, even people typing can be heard quite audibly. Please, can you keep your microphone switched off unless Mr. Gould or I invite you to speak? And I'll have to remember to do the same myself. Please use the technology carefully and responsibly. I'm sure you all will. I'll remind you of our powers of control over the hearing and its conduct, and any disruptive behaviour will affect the ability of other parties to participate and will not be tolerated. I did have a hand up there from Mr. Garbett. Mr. Garbett, did you wish to say anything at that point?
Yes, good morning, sir. Sorry, I didn't know if you'd finished the names yet, but I was intending to speak today.
Yeah, apologies, Mr. Garbett. Apologies. In my rather crowded list of people, I jumped from Surrey County Council to Painshill Park Trust and missed out Park Barn Farm. My apologies. You were on my list. Is there anybody else from Park Barn Farm wishing to speak today, Mr. Garbett?
My client has not been able to get on, so it's just myself on the line today.
Okay. Thank you very much, and once again, apologies for missing you off my rather crowded list.
No, it's sorry, it's Keystone Law as well, representing Mr.
Thank you very much.
Thank you.
And as Mr. Garbett has just admirably demonstrated, we do have a hands up function on the team bar. I don't think everybody in Teams has got it. Depends on which version you're using, but most people do have the hand up function. And clearly, if you wish to attract the attention of Mr. Gould or I or the case team, please raise your hand. Obviously, it gets very crowded if everybody starts putting their hand up, but if you really do need to attract our attention, then the hands up function is the way to do it. And once you've been heard, please then lower your hand using the same button. Thank you very much. Right, I shall now just run through some general housekeeping matters. The agenda that I tried to share earlier was attached to the email with the joining instructions. You should be able to see it on your screen if you've downloaded it separately, or hopefully you might even have managed to print off a hard copy of it. The one thing that is quite crucial is, obviously you're at liberty to leave the hearing at any point, but please let us know if you're going. It'd be really helpful, because otherwise the case team will be searching for you, and you've left the hearing because you said your piece and wanted to leave. So if you could just let us know when you're leaving, it saves somebody having to try and search for you and get you back, in effect. If you lose your connection to the hearing and you don't wish to leave, then please try to rejoin using the same joining instructions that you have already used. If you're not able to rejoin using the web address, then please try the telephone number. If you continue to have problems, then please contact the case team using the contact details provided in the joining instructions. Unfortunately, if you're just completely unable to rejoin, then please access the recording. And if you did wish to make any representations based on the recording that will be published after the event, please make them by the next deadline, which is deadline 11, Friday the 3rd of July. We will not be issuing any notes of this hearing, so please keep your own records as necessary. Depending on the length of today's session, we will be stopping for a comfort break, and if needs be, we'll also be breaking for lunch. Things will probably move a bit more slowly than they would in a face-to-face hearing, so Mr. Gould and I should take that into account. If at all possible, when we do adjourn for a break, it's probably best if you don't log out. But if you don't want to see us get up and move around the room, etc., in the various noise of putting the kettle on, then please turn off your video and your microphone, and that way we'll just see your icon, but we won't see anything else. And obviously turn it back on again when we're ready to restart once the adjournment is over. On the examining authority's behalf, Mr. Price from the Planning Inspectorate, who's really drawn the short straw, will be sharing a small number of documents. If possible, you'll probably find it useful to also have those documents to hand if you've got them in either hard copy or if you've already downloaded them separately onto your device. The agenda letter sets out the documents that we will be referring to, and it is suggested that you make sure that any documents you need for the hearing are available to you. Mr. Gould or I will say when a document is being referred to and will provide its examination library reference number when we refer to it. As far as reasonably possible, because we could have people on the phone who aren't able to see anything, we will also describe the relevant contents of the document that we're referring to. As this process might take a bit longer than is usual, we will endeavour to allow sufficient time for all of you to access the relevant documents. Now, due to the large size of some of the original plans, particularly the plans that are made up of multiple layers, the applicant has sent us compressed versions that we will be using for the purposes of this CA hearing. The reason for that is that they load far more quickly. Some of the uncompressed plans were taking up to 5 minutes to load. So we've got compressed versions of certain plans from the applicant. They're exactly the same, that they're not new plans, they're only compressed copies. The only trade-off with having compressed copies is the detail isn't quite as good. So they're not as easy to see on the screen, but they will load an awful lot more quickly than the original versions. As I said previously, if you're not able to see a document during the hearing, then you may wish to go back and access the recording of this hearing and refer to the documents then. You will then be able to make your post-hearing submission based on those documents and what you can see if necessary. Just a few other points regarding the way that we will be using Microsoft Teams technology today. Firstly, either Mr. Gould or I or members of the Planning Inspectorate's case team are the only people who will share documents onto the screen today, please. If you do want to see a document other than those indicated in the agenda, then please let us know at the appropriate point by providing the examination library reference number. Mr. Price will then access the examination library reference, find it, bring it up and share it. Obviously that will take some time, so please try and keep this to a minimum. But if there's a document in the examination library that you really feel you need to refer to, then please do so. But just bear in mind that will cause a delay and we'll have to wait for that to be shared with us. Secondly, the chat function on Microsoft Teams does not form part of this hearing and is not to be used. Thank you. Any written submissions should be emailed to the case team at the appropriate deadline, and we're not accepting any written submissions via the chat function on Teams. Okay, I'll just briefly turn to the purpose of the CA hearing. The purpose of today's CA hearing is for us to hear from all affected persons, APs in short, and the hearing will begin with this session looking at general compliance with policy before, in the second set of sessions, looking in more detail at specific plots and site-specific matters. We do not expect parties to treat this hearing as an opportunity to set out their full cases. We've already got written details of your cases, or to divert the hearing from the specific matters at hand. So we are here today to look at CA matters. Just before we go into the main part of the session, I shall hand over to Mr. Gould in a minute, but please provide comments, questions and answers when invited to by Mr. Gould or I. Please try not to speak over other people. It gets very difficult when you're in a virtual event if everybody's trying to speak at the same time, but we will try and provide regular opportunities for people to speak, and don't forget the hands up function. Please, would anybody who speaks provide a written summary of their oral representations with the post hearing documents, and that's by the next deadline, deadline 11. As I've already said, we anticipate having shorter sessions and taking more breaks than is usual in order to account for the virtual nature of this hearing. Okay, before I hand over to Mr. Gould, are there any questions about the agenda or anything I've said so far? No hands up, nobody wishes to speak. So far, so good, in which case I shall now hand over to Mr. Gould to take us through the next part of the agenda, and that starts with agenda item 2, the applicant's case for compulsory acquisition and temporary possession. Over to you, Mr. Gould.
Thank you, Mr. Jones. The way I was proposing to hear the applicant's summary was to do that effectively in one hit. Now, what we have been thinking of is that we will, in effect, sit for an hour, take an adjournment for 10 minutes, then recommence. Mr. Humphreys, are you leading on this agenda item? And if so, do you think you will be able to get through it all in summary by around 11 o'clock, or do we need to think about how we might break it up before you start?
Sir Michael Humphreys for Highways England. Yes, I would anticipate we would get through it by about 11 o'clock. Is it possible that we could run over a little bit? Yes, but I would hope by not very far.
Thank you, Mr. Humphreys. That's very helpful. What I'm going to do in a second is ask you to go through those issues that we listed in the agenda A to F. But before you get to F, which of course is a little way down the track, the legislative update, I'll give a prompt as what we're looking for in that respect. But if you're content to start with item 2A, then please do so.
Thank you, Mr. Gould. I should just say everyone who followed me introducing themselves said that they could both see and hear Mr. Jones. I can hear Mr. Jones, but I can't see him. I get an icon with GJ. I have to say, and Mr. Jones, don't take this the wrong way, I don't feel in any sense at a disadvantage. Lovely to see you, I'm sure, but I apologise, but I can't actually see you. I don't think it's important. However, I can hear you.
That's fine, Mr. Humphreys. I am probably best heard and not seen anyway. So.
Thank you, Mr. Humphreys. Just before you begin, I'll explain a little bit about that. The way the software seems to work is it picks up who's been speaking most recently. So anybody that hasn't spoken for a while will drop out and be replaced by somebody. That is why it is a little bit difficult to follow on screen. So
yes, I can see the icon for Mr. Jones, but it's just a pink circle with GJ. So let's not spend time on it. It's just one of those obviously little glitches, but it doesn't seem to matter.
Well, just on that, I will also explain that Mr. Jones and I potentially will take over navigating certain documents that Mr. Price displays. At that point, neither Mr. Jones or I can see you necessarily, which makes life a little bit difficult as well.
Oh joy, sir, for you. So I'll start then setting out the applicant's case. So the applicant's overall approach to and justification for the use of the compulsory acquisition and temporary possession powers comply with section 122 of the Act, and we set that out in the statement of reasons, which you have in the original form as APP 022. So I'll just sort of unpack that, if I may, a little bit. Section 122 sets out various legal tests where a development consent order includes compulsory acquisition powers, and section 1221 says that we must comply with subsections 2 and 3, and subsection 2 is the one that says, well, we have to require the land for the development or to facilitate or for something incidental to the development or for replacement land, and section 122(3) says that must be a compelling case in the public interest, and this was the statutory formulation of a concept which had always existed for compulsory purchase orders in policy terms. So if I sort of then just deal with those things. So firstly, the requirement for the land. Appendix A of the statement of reasons sets out plot by plot what each plot of land is required for by reference to the particular work number in Schedule 1. That's the list of the authorised development, and maybe in later sessions as part of session 2 we'll talk about particular plots and particular objectives, but in general terms it's Appendix A that sets out why we need the land or the rights or the temporary possession. So as far as the compelling case in the public interest is concerned, we set that out, our general case on that, in section 5.4 of the statement of reasons. I'm not going to try to summarize all of that, but clearly the case set out on a need basis based on both the national policy statement for national networks, the road investment strategy, the improvements that Highways England has identified itself as being necessary to improve junction 10 of the M25 and the roads immediately around it. As far as alternatives are concerned, to this scheme have proposed, again, that's touched on section 5.5 of statement of reasons, but in a compulsory acquisition sense, there are, I suppose, 3 parts to that. One is looking at the overall scheme options that we examined, and you may recall in one of the earlier issue-specific hearings there was some discussion of that, and Mr. Bowen, I think it was, went through the various stages of scheme selection with options 9 and option 14. I won't repeat that. The second level at which alternatives are looked at really is more detailed.
Sorry, Mr. Humphrey, to interrupt. I'm definitely having some issues with being able to hear you. I don't know whether anybody else is at the moment, but your line seems to be breaking up a bit. Has anybody else, Mr. Jones, have you encountered?
So Mark Challis from Highways England. Mr. Humphreys is breaking up, I'm afraid, for me a little as well.
Yes, there's a slight bit of breaking up of Mr. Humphreys. I mean, I can get the gist of what he's saying, but there are the odd words that are being missed.
I think what we might have to do, Mr. Humphreys, if we'll carry on for a bit, if it continues, you might have to go to video off and audio only, which apparently helps bandwidth and might make your signal stronger for the rest of us.
So I'm very happy to do that. Now, I'm not precious about being seen. It's really the words that count. So I'll turn video off, and I may turn it on again later.
Yeah, happy to proceed on that basis.
So I was explaining the way in which we had approached alternatives, you know, at three levels. One, the overall sort of scheme alternatives level, but then secondly, we've looked to minimize land take in terms of the final scheme, and those are more detailed changes to the scheme to reduce landscape. I may touch on those a bit later. And then the third way in which we obviously look at or consider alternatives in a compulsory acquisition sense is that we consider whether we need acquisition of freehold, or whether the acquisition of rights would be sufficient, or whether the acquisition of or rather the taking of temporary possession powers would be sufficient. And again, you know, that can be explored later, but that's the overall approach. So we have, as you know, introduced a number of scheme changes during the course of the examination. Changes 1, 2, 3, 5, 7, 8 and 9 do involve some, albeit modest, either additional land or changes to use of land. So I don't think for present purposes it's necessary for me to go through each of those, but I can certainly do that if that would be helpful to you. And therefore I'll turn now to item B in your agenda, which is to review the human rights considerations. And so the Human Rights Act 1998 incorporated the European Convention on Human Rights. That's the United Nations Convention for Europe. And the particular articles in the convention that are engaged are Article 1 of the first protocol. Lawyers sometimes call that A1P1, but Article 1 of the first protocol to the convention, and that's the article that deals with peaceful enjoyment of possessions, and it's a qualified protection. It's a qualified protection. So would you like me to pause for a moment?
I think you can continue, Mr. Humphreys. Thank you very much.
Thank you, sir. I know that you mentioned that Mr. Gould might have to take a call. So
sorry, everybody. The phone went, but nobody's left a message, so we'll continue. Thank you.
Mr. Gould, of course. The A1P1 protection of peaceful enjoyment of possessions is a qualified right, so it's a protection, but except in the public interest. Clearly, we say that this scheme is in the public interest. The second convention right that I'll touch on is Article 8. That's a respect for private life and home. That would certainly relate to residential properties. And again, this is a qualified convention right, so it's except in accordance with the law and where it's necessary in the interests of public well-being. Again, clearly our case is that qualification applies. And the third convention right that is potentially engaged is obviously the right to a fair hearing. That's the purpose of why we're here today, to make sure that people have the right to make representations on the particular project. And so when you look at the compulsory acquisition guidance, that's the old DCLG guidance. I say old because it used to be DCLG, but it's still the current guidance. Paragraph 8 points to three sort of tests. One is that the purposes of acquisition are legitimate, that they're also necessary and proportionate. And in section 6 of the Statement of Reasons, we have dealt with those. We say that this is a proper purpose. This is for the improvement of the M25 junction 10 and the highway network surrounding it. The taking of the land is necessary. I point to the Statement of Reasons Appendix A and the need to be exercise the compulsory acquisition powers. And also, as part of that, I just make the point that, of course, all those who have land taken from them or who might in other ways have a relevant claim are entitled to compensation. We'll deal with that under the funding statement. So, as I mentioned before, in terms of proportionate, the exercise of the powers under the DCO are proportionate. We've looked at where we have to have freehold, where it would be sufficient to have rights, and where we only need temporary possession. And so our case very clearly on those things, which really relate to Article 1 of the First Protocol and Article 8, are that we satisfy those articles and that the scheme, its acquisition, is legitimate, necessary and proportionate. And as far as Article 6 is concerned, again, we say that the procedures implemented by the Secretary of State and PINS are sufficient to satisfy that particular article. So I was proposing then to move to sub-item 3 in your list, which is to consider the structure and contents of the Book of Reference. So the Book of Reference is a document that is required under Regulation 5 of the Infrastructure Planning Application Prescribed Forms and Procedure Regulations 2009, but its form is set out in Regulation 7. We have followed Regulation 7 in the way that we have set out the Book of Reference, and we've also taken into account the guidance that was issued by DCLG, now MHCLDG. So the Book of Reference, as is required, contains 5 parts. Part 1 includes the category 1 and category 2 land. These are the categories set out in section 44 of the Planning Act 2008. Part 2 includes the category 3 land. So these are the land typically not within the land to be acquired, but where parties or landowners may have a relevant claim, and that's a claim either under section 10 of the Compulsory Purchase Act for the execution of works where land has been injuriously affected, or part 1 of the Land Compensation Act 1973 for the use of works. This is for things like noise, vibration, and so on. And so we, in this Book of Reference, have broken down part 2 into a part 2A and a part 2B. Part 2A being for section 10 parties and part 2B for part 1 parties. So that is the Book of Reference. In compiling the Book of Reference, the land referencing was carried out by a specialist land referencing agency, and the district valuer also was involved in the process of identifying the Category 3 persons, and the way in which we identified Category 3 persons is set out in section 4.6 of the Statement of Reasons, and it was undertaken on a precautionary basis. So I should add here that just because someone is not identified as a Category 3 person in the Book of Reference does not preclude them from claiming compensation. They're perfectly entitled to claim compensation. Whether or not they be successful is a different matter. But the identification in that part of the Book of Reference is necessary for certain notification procedures. The Book of Reference also, perhaps slightly unusually compared with some, includes what we've called orange land. So this is land within the overall order limits, but land where we are not acquiring the land or taking temporary possession. And there are a number of reasons why we've done that, but in very broad terms they are that where land we just simply want to create or enhance a right of way, and once we've done that we don't need any longer term right, or land which forms part of a historic common over which compulsory purchase powers are not sought, so that we don't engage special parliamentary procedures, or where provision is made in the development consent order for a speed limit change, for example, and we don't need anything else, and so we don't need to acquire the land. And there is one plot, 8/15, where the land contains some existing utility infrastructure which is not affected by the scheme, but it's been excluded for purposes of clarity. So the Book of Reference there is a living document. It's had some updates at various different stages, but it is in conformity with the legal requirements. So I move on to agenda item sub-item D, the funding statement. Again, this is a prescribed document. It's required by Regulation 5 of the regulations I mentioned earlier, where a development consent order includes compulsory acquisition, which it does here. And the compulsory acquisition guidance, I point in particular to paragraph 9, requires applicants for compulsory purchase to demonstrate that there is a, quote, reasonable prospect of the requisite funds for the acquisition becoming available. So there's a reasonable prospect test. The funding statement here includes the overall capital cost estimate for the project at £272.6 million. That includes both capital costs and the cost of land acquisition, and the land acquisition costs are 23.5 million. They're set out in another part of the funding statement, and so in fact the scheme changes, or some of the scheme changes that occurred early in the project, are expected to reduce some of the costs. So in relation, I'll just touch on it to blight. Obviously the 23.5 million does include blight, and it's important, sir, to note here that we're talking about statutory blight. So this is not what is sometimes called generalized blight, people saying, look, you know, I've got a particular project over there that's blighting my land. This is statutory blight, and this relates, sir, to the Town and Country Planning Act, section 149 and following, especially section 150 and schedule 13 of that act, which was amended by the Planning Act 2008 to bring development consent order projects within it. And in effect, it's whereas here there is a proposed project, someone's in it, they've tried to sell their land, they've made reasonable endeavours, but they can't. And in those circumstances, because they're within the order boundary, they may have a blight claim, and so that's what that is dealing with, and the overall sums we've budgeted for include that. So as is entirely normal in these things, we don't break down the overall, the global sum for compulsory acquisition to individual plots or landowners, because that's obviously sensitive information in the context of the negotiations that we're having with landowners. We say, and we are very confident, that there is overall a reasonable prospect of the funding being available for the scheme. And we also say that in relation to the green element of the Cockcrow Bridge, that's work number 35B, that again, change one sought to introduce that as a green bridge, as I mentioned, and the funding, we're confident that there is a reasonable prospect of the funding being available for that as well. But you will have noticed that in the event that that funding was not approved, requirement 9.3 of Schedule 2 does permit the Secretary of State to remove that green verge element. So I move on to sub-item E, which is to consider the structure and content of the statement of reasons. So this is a prescribed document. We need to have one where there is compulsory acquisition, but it does not have a prescribed form. But we've followed the general approach of other Highways England DCO schemes, and indeed other schemes more generally. There have been a large number now of DCOs. Most of them will have compulsory acquisition, and therefore there are a lot of precedents out there for statements of reasons, and we've followed a very conventional structure there. As I've said, Section 5 in particular sets out the case for compulsory acquisition, and you will be, I know, familiar with that. The statement of reasons also provides information on particular categories of land given statutory protection, such as statutory undertakers land, crown land, special category land. And in relation to special category land, there's an appendix, Appendix C, which sets out the common land and open space points in a bespoke report. And so you've obviously set a separate compulsory acquisition hearing for that, and the statement of reasons has been updated to reflect the scheme changes. So that brings me to, tantalizingly, to your item F, to consider impending legislative changes, and you said, so you would indicate what those were. We weren't aware of any, but I'm happy to try and respond as best I can.
Thank you, Mr. Humphreys. There's nothing magical about it. This really revolves around the issue of some changes being made to temporary possession under the neighbourhood planning legislation, the 2017 Act, which are written into the legislation, but as far as we understand, still have not been fully enacted. Is that your understanding of that legal provision at the moment?
Yes, sections 18 to 31 of the Neighbourhood Planning Act introduced a new regime for temporary possession that would apply more widely than just for development consent orders. And this was obviously important, sir, because whilst development consent orders can create powers of temporary possession, other types of procedures for the compulsory purchase of land, compulsory purchase orders, don't, unless there is something in the particular what's called a special act, the authorizing act, that allows that. So the purposes of sections 18 to 31 were to widen this. You're absolutely right, sir. These are not in force. Those provisions are not in force. And so far as I am aware, and I did have a look at this quite recently, there's no indication that I've been able to find of any proposal to introduce those provisions on a particular timescale that I could give you. Sir, you will have noticed that Article 3 3 of so 3 sub 3 of the DCO does seek to disapply the 2017 Act. We've taken the view on this that clearly the Secretary of State, as part of government, will have a view on whether the Neighbourhood Planning Act provisions are or are not going to come in force. The Secretary of State for Transport will clearly be the decision maker on this development consent order, and therefore it is in effect with the Secretary of State, or if I can put it like this, more widely with government, to decide whether our provisions are appropriate and adequate, or whether the provisions in the 2017 Act are. But as far as we're concerned, and as far as we're aware, those provisions are not about to come into force, and therefore you should work on the assumption that our temporary possession provisions in Articles 32 and 33 apply. So, and I think I've finished with 2 or 3 minutes to go, so I've just about complied with your timescale.
Thank you, Mr. Humphreys. You've actually done very well.
Can I turn my video on, sir, just so that you can all have a final glimpse of me before the break? And apologies.
No, it's a technical issue that we have been aware of, even without working in the virtual environment, when we're communicating with one another internally within the inspectorate, outside the NSIP arena. It did seem to cure the problem, and it may well be that for others later on today and throughout the week, we will have to go down that route. It's a little unfortunate because, of course, whoever is speaking at the time can't see others, but it did mean that we had a consistent run of you giving your presentation, which was about 20 minutes, which was very helpful.
Yeah. In fact, sir, I was able to see you and the icon for Mr. Jones. It's I think simply that you weren't able to see me, and I didn't see myself in that little icon in the bottom right-hand corner. So it was of no disadvantage to me at all.
It's fair to say I think we're all on a learning curve as far as how this kit works. We've done pretty well, I think, so far this morning, I have to say, given some of the testing that we've done in the background. We've encountered a lot more issues than we had this morning.
There's still time, sir.
Oh, yeah. We are coming to 11 o'clock. What I was proposing to do is, having given the applicant the opportunity to deal with this very high level compulsory acquisition and temporary possession material, then invite any affected person who might want to comment on anything in A to F. But I think it's a convenient time at this point that we do take the 10-minute adjournment and we come back at 10 past 11. Mr. Jones, do you think that's an appropriate thing to do?
Yes, thank you, Mr. Gould. Yes, that seems reasonable to me. And as I said earlier, the best thing to do is for everybody just to turn their cameras off and turn the microphones off, and then at 10 past 11, turn them back on, and everybody will magically reappear.
Importantly in that, please do not hit the red phone button because that will disconnect you.
Thank you, sir.
Okay, so we are now adjourned then until 10 past 11. Well, welcome back, everybody. It is now 11:10, so the hearing is resumed. I can see Mr. Humphreys. Is everybody else, as far as we know, present that was present before the adjournment? I can see Mr. Garbett.
Yeah, looks like we've got everybody online and present. Thank you very much for returning promptly. Much appreciated. Over to you, Mr. Gould. The one thing I would say before Mr. Gould starts, I don't know what it's like in your houses, but it's fairly stuffy in here. So if you do feel the need to take off a jacket if you're wearing one, then please feel free. Don't stand on ceremony on our account. Thank you. We have a hand up from Mr. Stempfer.
Yeah, what I'd like to do for this session, what I'm going to ask for in a minute is we'll just ask for affected persons' responses to what we've just heard from the applicant. What I'd like to do is, in effect, I'm going to quickly go through all of the affected persons just to get an indication as to whether or not you do wish to speak to this item. Mr. Stempfer, that might address your question, but please raise it now.
Thank you, sir. David Stempfer, Surrey County Council. I actually raised my hand to say that I could hear you, but the technology won't let me lower my hand. So just to comment on what we heard this morning, just to confirm that Surrey County Council has no comments to make at this time. Thank you.
Thank you, Mr. Stempfer. In terms of the hand raising thing, the way it usually works is you, having raised it, if you click on it again, it should lower it.
Thank you, sir. David Stempfer, Surrey County. That didn't seem to work for me, but it seems to have gone down now. So thank you.
Thank you. Right, I'm just going to run through then in order of the other affected persons, starting with Mr. Garbett. Do you wish to speak to this item?
Yes, I do.
Okay. Sorry, can I just run through who does and doesn't want to, and then I'll come to you in a minute. For the Girl Guides, is there anybody, Miss Donovan or Miss Wicks, do you wish to speak to this item?
No, we don't. This is Christine Donovan.
Thank you. Mr. Alder, do you wish to speak to this item?
So is that for James Adler at the Wildlife Trust?
Yes.
No, we don't want to. Thank you.
Thank you. Mr. Max, do you wish to speak to this item?
Richard Max for the RHS. No, sir. Thank you. We don't wish to speak to this item.
Thank you. Just before I turn to Mr. Garbett, who did give in, is there anybody in terms of AP affected persons that I've missed? I don't think I have. So the reason why I'm looking up at the screen is I can see all the attendees. We've got various screens and various things available to us, and that's why at some times during this hearing you might think we're not paying attention. I'm afraid it's just we're looking at multiple screens and multiple documents just to keep a pace with what's going on in the background, mainly to make sure that people aren't dropping out. I have heard anybody else saying anything in terms of wishing to speak to this. So it looks like, Mr. Garbett, it's over to you.
Yes, sir. Thank you. I might decide to turn my camera off because I have had a few issues with other Zoom and team calls. So if that's okay with you, I think it might well improve the performance of the sound. So I shall do that now. So I think before I launch into it, the point I wanted to raise really first is whether this is appropriate for today or tomorrow. I suppose the issue I wanted to raise in response is how one should tackle the question of the statutory test, at least in practice, without actually entering into the points which we've raised in relation to Park Bar Farm. And I was going to leave out of that the historical precedent issue.
Yeah. Mr. Garber, I think I might be able to assist with that. Mr. Jones and I well understand the case that you're making on behalf of your client. I'm sure the applicant does, and for that matter, I'm sure Surrey County Council does. Really, I think the purpose of this session is to look at more strategic type issues before we start delving down into site-specific matters. And I think in that regard, particularly paragraph 16 of the government's guidance on compulsory acquisition might assist particularly in that regard, where if there is an issue such as that you're raising on behalf of your client, that there is a concern that possibly too much land is being sought for acquisition, the options that are available to, firstly, the examining authority to make a recommendation to the Secretary of State, and then the Secretary of State to consider the issue are, should all of the land that's proposed for acquisition be acquired? Should none of the land for acquisition be acquired? Or something in the middle where there might be the potential for both a recommendation from the examining authority and then a subsequent consideration by the Secretary of State, whereby the view is taken that perhaps more land than is necessary is being sought for acquisition, and potentially through the making of an order, if that's what the Secretary of State is minded to do, some of the land subject to the proposed acquisition might not go forward in the made order. Now, as I say, I suspect when we get to deal with your particular concerns about special category land in the session that we're holding tomorrow, a lot of that will come out in that discussion. So really, I think the primary purpose of what we're doing this morning is just really to set the very high level context. Are you content to proceed on that basis, or is there a further point you wish to make?
Well, no, so I think that's the gist of the question I raised. That, as I see it, at least, there is a correct approach to how one must follow through the statutory test, and you are correct in highlighting the fact that we feel that test has not been properly carried out. So really, if I did continue, it would just be to put, I suppose, what we say is the correct sequence, I should say, of steps, which guarantees that one has followed that test through properly, and in particular, one has satisfied the section 112 subsection 3 test of a compelling case in the public interest, something which guarantees human rights protections are also adhered to. So it was a high level point, but it does, I admit, flow straight into, I think, the site specifics of the Park Barn Farm objection, and why that in particular should lead to one striking out, as we say, the parcels which have been identified on that land. So I'm happy to deal with it tomorrow, but it just may well be that we have more to say tomorrow.
Thank you, Mr. Yeah, thank you, Mr. Garbutt. I think hopefully you've seen the agenda for tomorrow, and of course the applicant has as well, and for that matter, Surrey has. I do think, and particularly the way I've structured some questions that are going to flow from those agenda items, we will definitely be touching on this matter in quite a lot of detail. Mr. Humphreys, for the applicant or anybody else from the applicant's team, is there anything you wish to add in response to what Mr. Garbutt has alluded to, in terms of, do you feel you need to say something at this point, or shall we leave the detail of the particular point that Mr. Garbutt has raised for tomorrow? Mr. Humphreys or somebody else from your team?
Yes, so Michael Humphreys. I would have thought this is a matter best dealt with tomorrow when we're looking at the particular issues, and if Mr. Garbutt's happy to deal with it on that basis, we would be more than happy to deal with it on that basis.
Thank you, Mr. Humphreys. For Surrey County Council, do you have any views on whether we, whether you wish to make a point in effect in terms of the higher level or the interrelationship between what is a site-specific concern and this higher level plane matter in terms of the way Section 122 operates. Anybody from the Surrey County Council team, please?
Thank you, sir. David Stent for Surrey County Council. I think the County Council prefer to discuss the topic tomorrow, so we can talk about the subjects in the round.
Thank you, Mr. Stent.
Mr. Gould, your microphone's muted.
Sorry,
You'll need
apologies.
To...
Mr. Garbutt, are you content to hold, I think, the detail of your argument over till tomorrow? What we've tried to do is, for tomorrow, make sure there's enough time to look at the points that you've raised and allow both the County Council and the applicant to respond to those points. Mr. Garbutt. You're muted, Mr. Garbutt.
Apologies, sorry. Yes, I believe that we can deal with things adequately tomorrow, and it may well be helpful to start somewhere along the lines of what I just suggested, with a discussion of how these statutory tests should, in the respective party submissions, be carried through in practice. But yes, I don't feel there's an absolutely critical need to deal with that today.
Thank you, Mr. Garbutt. I mean, the way tomorrow's session is, if you like, planned out, is that we'll give the applicant the opportunity to have their say about special category land. Then Surrey will get their say about special category land. Then you'll have your say in your client's behalf, where you will be able to develop the finer points of your argument, and then we as examining authority will have a series of questions that will build, I'm sure, from all of that.
Yes, sir. Thank you.
Thank you.
That's fine. Thank you.
I therefore think that as far as item 2 is concerned, we have heard everything that we need to up to this point. Before we move on to no, apologies, I did have a specific question. And this is for the applicant, and it revolves around the funding position. As I understand it, having read what's said, particularly in the funding statement, so that's APP -024, what seems to have happened is that the Road Investment Strategy 1 had a period that ran up to 2019-2020, i.e. the end of the financial year, but then was granted an extension to take it on to an extra year, which expires on the end of March 2021. Really, my question is that firstly a correct understanding? And what would be the situation with funding if for any reason, if the Secretary of State is minded to make the order, but that decision is delayed beyond March 31st, 2021, what is the position with funding? Is there a rolling provision, or would the applicant have to make a bid back to parent department to secure the funding? Mr. Humphreys or anybody else in your team, can you respond to that?
Yes, that's obviously something, because it's sort of in effect internal to Highways England's kind of operations and their relationship with the department, that I'll ask Mr. Wade, that's Jonathan Wade, to comment on. I believe he is still on the call, so if Mr. Wade could deal with that, I'd be grateful.
Thank you, Mr. Wade.
Good morning, sirs. Jonathan Wade, Project Manager for Highways England. This scheme is a Road Investment Strategy 1 scheme, so the funding for it was secured in the Road Investment Period 1. The fact that it is going to be delivered in Road Investment Strategy Period 2 has no bearing on that. it seems to have gone very quiet. Did you were you able to hear me at that point?
I heard you think, yes, I was just making my note. Of course, that's the other disadvantage of not being in the room with everybody. You can't see my pen speed and I can't see anybody else's pen speeds.
And I heard you as well, Mr. Wade, loud and clear.
Thank you.
Thank you, Mr. Wade. I think that succinctly answers the question, i.e. that we don't have a concern about any issues about funding rolling on even beyond 31st March next year.
That's correct.
Yeah. Thank you. Then I think that does conclude agenda item 2, unless Mr. Jones, have you got anything you wish to raise?
No, nothing at this point, Mr. Gould.
Thank you. I think we are actually making quite good progress. So we will look at agenda item 3. Originally, we thought that if we hadn't made good progress up to this point, Crown Land and statutory undertakers issue might be something that we'd hold back to the end of day 3, because that's really something just for the examining authority to explore with the applicant. But as we are making good progress, I think we will do item 3, and I think we will also be able to do item 4, which was in a similar sort of category, without too many difficulties, because I don't have too many questions, and I don't think Mr. Jones has got too many questions relating to either agenda items 3 or 4. So if we can therefore turn to agenda item 3A, which is the position with statutory undertakers, particularly sections 127 of the Act and then 138 of the Act. So if we can deal with section 127 first, please. Mr. Price, can you bring up Rep 8-025 on screen, which is the document that deals with section 127 matters for statutory undertakers? It's in effect the summary of where the applicant has arrived at up to this point. And really, Mr. Humphreys or anybody else from your team, really what I'm just looking for is an update, particularly in respect of the position with regard to Affinity Water, because it looks like you've got matters resolved with National Grid.
Yes, Michael Humphreys for Highways England. Please tell me if again, there's a problem with me having both audio and video on, but I'll assume it's okay. So yes, in relation to that document, the document that is currently on screen has a schedule 1.
Sorry, I'm just going to, yeah, thank you, Mr. Price. Can you just roll down?
It's on page 5 of 7. Yeah, and that schedule sets out for the 2 parties where settlements have not been reached, the position, the sort of update I have on that is that with National Grid, I think we're now in the position where we have agreed protective provisions with them, and we're finalising, in effect, the land and works plan aside agreement with them. With Affinity Water, again, I believe we're in advanced negotiations, and as far as I understand it, we anticipate agreement being reached with both of them before the end of the examination period.
Thank you, Mr. Humphreys. I'm going to ask a recurrent question that I think I asked on a number of occasions during issue-specific hearing 2 way back in January, because we're in a slightly different context now. The close of this examination is the 12th of July. For us to be able to understand what the position is, we will need some sort of update by that close. Otherwise, we're left in a slightly difficult position in terms of how we report things to the Secretary of State. So is there a good prospect that, particularly with Affinity Water, which seems to be not quite well as advanced as National Grid, that there will be a firm indication that agreement has been reached, even if the paperwork hasn't been fully concluded?
So that is my understanding. I think we have Mr. Barker, John Barker, on this conference call, and also representatives from BDB Pitmans. They will be closer to those negotiations than I am, and they may want to add something, or indeed correct me if I've misunderstood the position. But my understanding is that we are working hard with both of those parties, and we're obviously very well aware of the end time for the examination and the requirements that that brings with it.
Thank you, Mr. Humphreys. Mr. Barker, is there anything that you can add, or Mr. Chalice or Mr. Spencer?
Hello, sir. John Barker for Highways England. No, as I understand it, the negotiations are as Mr. Humphreys set out, and we will aim to have something for you by deadline 12.
Sir, Mark Chalice for Highways England. Just to add to what's just been said, and as can be seen on the screen, we don't think that there should be any reason why Affinity Water wouldn't come to an agreement before the end of the examination. So, we're confident and hopeful that they will.
Thank you, Mr. Chalice. Just whilst Mr. Gould is writing and composing his thoughts, I think it's something you might hear a few times over the course of the next few days. But clearly, if any of these outside agreements, or in this case protective provisions, aren't agreed by the close of the examination, then at the last deadline we'll need a position statement from both parties setting out exactly where you are with your negotiations.
So thank you for that. That's very well understood, and we're clearly working very hard towards that.
Thank you, Mr. Humphreys. Okay, Mr. Gould, you ready?
I am, thank you, Mr. Jones.
Okay, I'll hand over to you.
Right, I'd like to do the same with the section 138 side of thing, which is really statutory undertakers and their apparatus. I'm not sure we necessarily need to bring up Rep 8026, which is the schedule, because basically that seems to say that there's a lot of negotiations still ongoing at the moment. But Mr. Humphrey, or possibly maybe Mr. Barker, are you able to give any update as to whether there's progress, or are we more or less in the same position as we are with the 127 side of things, that work is in hand and you're doing your best endeavours to get to a position of agreement by the close of this examination on the 12th of July, and as Mr. Jones indicated a minute ago, if needs be, we will require just a position statement to inform us as to precisely where you are at deadline 12. Anybody from the applicants team?
Yes, sir. Michael Humphreys, Highways England. So this item is dealing with section 138, that's extinguishment of rights in relation to apparatus for statutory undertakers, and the test is necessity. Is it necessary for us to extinguish those rights? The schedule in the document Rep 8-026, Schedule 2 in that document, lists a large numbers of parties. I'm pleased to be able to say that with two exceptions, agreement has been reached or no objection has been received from the statutory undertakers affected. The two exceptions are Affinity Water, with whom negotiations are still ongoing, and Southeast Power Networks, with whom discussions regarding the standard form of documents to be appended to the agreement reached are ongoing. Again, subject to anything that Mr. Barker or Mr. Chalice may wish to add. My understanding is that we again anticipate that agreement will be reached before the end of the examination period, so that we can update you in good time.
Thank you, Mr. Humphreys. Anything to add, Mr. Barker, to that?
John Barker for Highways England. As I understand it, the agreement with Southeastern Power Networks has been reached. It's just awaiting signature.
Thank you, Mr. Barker. That's very helpful. So it looks like the only real position statement we're going to need at, well, the only area of doubt at the moment is Affinity Water, and then the position statement in respect of all of these Section 138 matters. We'll just need to, set out precisely where you are with each of the listed parties. Mr. Jones, have you got anything you wish to add on statutory undertakers at this point? Otherwise, we'll move on to Crown consent.
No, nothing to add at this point. Thank you.
Thank you. Well, then, turning to Crown consent, can we have an update from any of the applicants team in respect of where you are with that at the moment, please?
Yes, sir. Michael Humphreys for Highways England. There are two different aspects for this. So I'll deal firstly with Crown land belonging to the Secretary of State for Transport. In relation to Crown land belonging to the Secretary of State for Transport, land was transferred under an agreement dated 30th March 2015 under Section 15 of the Infrastructure Act 2015. The transfer of that land has been going on a rolling programme since then. This is part of the new status for Highways England, and as a result of the transfer of titles within the footprint of this scheme, there is no longer any Crown land in the ownership of the Department for Transport, shown in the book of reference that was submitted at deadline 8. So as far as Secretary of State for Transport is concerned, Crown consent issue goes away. So we've noted in sheet 2 of the Crown land plans, it incorrectly identifies plot 2/27B as Crown land, and this is simply an error, and it will be corrected in the plan submitted at deadline 11. So there's another aspect of this. This is Crown land belonging to the Secretary of State for Environment, Food and Rural Affairs, and the Crown land there relates to plots 1/14, 1/15, 1/18, 1/18A, and sorry, 1/21 and 1/22, as shown on the land plans. The Highways England's agents and legal representatives are continuing to engage with those acting for the Department for Environment, Food and Rural Affairs and its solicitors in order to obtain the certificate of consent. Clearly, yeah, as you will know from experience on other projects, the department, moves at its own speed, and we're doing whatever we can to make sure that we get the appropriate consent in the appropriate time. We don't understand there to be any DEFRA objection to the scheme. I think this is simply a question of going through the necessary processes. Again, it may be that Mr. Barker or Mr. Chalice want to add something, but they shouldn't feel the need to speak unless they've got anything to say.
On Crown land, therefore, is there anything that anybody else from the Highways England team feels they need to add? Deathly Science suggests not. All I would say, particularly with respect to the DEFRA land, of course, if there isn't consent by the time the examination closes, all we will be able to say as the examining authority in our report to the Secretary of State is, as things stand, Secretary of State, you could not grant the consent over that affected land without DEFRA giving its consent. And that's basically where we'll be at. So understand the difficulty with other department, but that's where we will be in that conundrum.
Yes, I mean, that's well understood. This is not the first time this type of issue has arisen on development consent order applications of this sort. This is ultimately a matter for different arms of government. We can only negotiate with DEFRA's representatives in the way that we have, but we're aware of the problem and we've made them aware of the problem. And as I say, we'll clearly have to give you an update at the end of the examination. We don't understand there to be any fundamental objection. It's just that we have not yet been granted the necessary certificate of consent.
Thank you, Mr. Henry. I'm just going to ask one last question, and it's really why this matter wasn't resolved before the application was submitted, which is clearly what the guidance, the compulsory acquisition guidance says, that this sort of matter should be addressed before the application is lodged. Anything you can assist us with on that point?
Yes, I mean, again, many applicants come up against this particular issue. Obviously, all applicants would like the department to grant the necessary consents and grant them immediately. Clearly, there are other pressures on any applicant, including Highways England, as to the delivery of their projects and the programme for those things, and they take proper decisions to try and move things along. I think maybe there's a wider issue here about trying to make sure that departments are able to respond in as timely as way as is possible. I do understand they've all had rather a lot on their plate recently.
Thank you, Mr. Humphrey. I think that answers that question as best as you can. So, Mr. Jones, have you got any other questions on Crown Land before we move on to agenda item 4?
No, nothing, Mr. Gould.
Right, before we do move on to tongue-tied, agenda item 4, is there anything further that the applicant wants to raise, either on statutory undertaker matters or Crown Land?
No, sir, there's nothing else as far as I'm aware.
That's helpful, thank you. Okay, so if we can now turn to agenda item 4, which is looking at site-specific objections for parties who are not making oral representations at this hearing. And in that regard, Mr. Price, can you bring up, please, Rep 10-010, which is the schedule of objections and compulsory acquisition objections from parties who have in effect made written objection, but we're not hearing from. And what I'm going to suggest, if we can ask the applicant, and it really is a question of who's best placed to run through that table and just give us an update as to what the current position is as we sit here today. Mr. Humphreys, are you placed to do that, or is somebody else within the team best placed to do that?
So it may be that that I am, although my understanding is that this schedule does represent the most up-to-date position that we have on this. I'm just going to see whether there's anything else that needs to be added, but this was a deadline 10, so very recent schedule, and as I understand it, it has been updated to reflect that. What I could do, because we have him on the call, Mr. Pugh, Richard Pugh, who was introduced earlier from the Valuation Office, and who has been one of the people most closely involved in this, could just be invited to see if there's anything he wants to add that is even more recent than this June document, June 2020 document.
Yes, thank you. Yeah, Richard Pugh from the Valuation Office Agency. No, I think that's up to date. I don't think there's anything substantial to add to the information on that table.
Thank you, Mr. Pugh. Well, I think if that's the case, then we really need not spend too much time looking at it or doing a blow-for-blow trawl through it. I think what I will do instead is raise some questions on some specific plots. Mr. Price, if you can unshare, I don't think we need actually, as I say, go through the document. Now, I'm not sure. I can see at the bottom of my screen various folders. Are those? Yeah, they look to. Fine. Okay, sorted. A wee technical glitch. Right. So as far as the agenda is concerned, I'm going to come on to a series of site-specific objections, really just asking for a bit more of a handle on the position. So I'd like to start with the former San Domenico site. Looking at Rep 10-0110, the schedule basically says there's been no discussion between the applicant and the objector since the 31st of January 2020. Basically, does this objection still remain live, and what is being done to try and resolve it in the background? And in answering that question, we need to be careful not to delve into the position with, of course, the undetermined appeal, which is being dealt with by an inspector, a different inspector. And of course, we just need to be careful in terms of what is said. Mr. Humphreys, are you in a position to really address whether there is any movement, whether it is a live objection, or is somebody else in the team better placed to do that?
Yes, sir. So far as I'm aware, it remains a live objection, but Mr. Pugh is probably the person who can update you with the, the absolutely up-to-date position, because I think he, from the valuation office, has been dealing with Monty Blackburn, the Monty Blackburn Limited, rather, the owners of that site.
Yes, thank you, Richard Pugh from the VOA. Yeah, that's right. So I think the appeal that you alluded to is probably central to Monty Blackburn's thinking, as far as we understand. And until they have a decision on that, then they haven't wished to engage with us in respect of this matter.
Thank you, Mr. Pugh. I thought we might hear something along those lines. And as far as I think this objection is concerned, when we get to writing our report, we will just, in effect, have to, set out what the facts are in terms of what is going on, and just flag up to the Secretary of State that there is an outstanding appeal and that things might change, and that he, following the closure of the examination, might see additional correspondence relating to that, but the examining authority won't, because it's unlikely the appeal will have been determined before the 12th of July. Mr. Jones,
yes, sir. I think to some extent the position on this and the appeal may have some relevance, perhaps greater relevance, not so much to the objection to the scheme, but to potential compensation. Clearly, if planning permission was granted, that may influence land values, and so of course the Secretary of State may be updated with what has happened in relation to that particular appeal, but Highways England's case for why it needs the land and the way in which it has re-provided access to that site will remain the same, whatever the outcome of the appeal.
Thank you, Mr. Humphrey. That's a helpful summary, and was more or less how Mr. Jones and I were thinking what was going on in the background. Mr. Jones, have you got anything you wish to add on this particular site before we move on?
Not on San Domenico, no. I think that's answered, as you say, that's answered the discussions that we'd had between ourselves.
Thank you. Right, I'd now like to quickly just turn to the Paynes Hill residents' objection. And to save bringing a document up, I'll read a quote which appears throughout Rep 10-10. This, for instance, appears for the entry number 6, but I say it repeats on a number of instances. What is quoted in Rep 10-10, or sorry, Rep 10-010, is that these category 2 and 3 interests cannot be acquired by the applicant, but meetings have been held in 2019 and 2020 with the Paynes Hill Residents Association, where residents have engaged on a variety of issues they have raised during the examination. Really, the question for the applicant is, can you please advise on what the precise status of these objections are in compulsory acquisition terms? And in effect, what does that quotation that I've just read out mean in, if you like, plain English terms? Mr. Humphreys or anybody else from your team?
Yes, sir. I will have to call on others, I think. I don't immediately have the document that you quoted from in front of me. I'm not quite sure whether this is going to be one for Mr. Pugh or Mr. Smith, or whether this is for others. Yeah, I think the point may be that they are not category 3 parties. It may be that I could ask Jackie Watson, who I think is part of this meeting, to comment on this. I don't know if she is able to unmute and add anything.
Yeah, just before anybody from the team comments on it, would it assist everybody if we did ask Mr. Price to bring the document up?
So I'm sure that would be helpful. And so I think also.
Sorry, Mr. Price, can you just point to entry 6 so everybody knows where we're looking? Yeah, you've got it. And really what I'm looking at is the quote in the far right column in that table.
Oh, I see, sir.
Sorry, Mr. Price, is it possible to enlarge that slightly at your end? Just to make it a bit easier for people to read. Yeah, I've just taken that as an example because that's the first entry. It repeats on all of the Paynes Hill residents who are referred to in that table, so it doesn't really matter which one we look at.
Right, so sorry, I now see what you're saying, and it may be that I can then help with this. The Paynes Hill residents are category 2, or as it says there, category 3 persons. And the point being with this, that we're not, take the example of category 3 persons, we're not actually seeking to acquire their land. They're outside the order boundary, and I think it may be that this issue, and as I say, Mr. Wade and possibly Ms. Watson have something to say on this, that obviously we're not acquiring those particular interests in land. As I say, I've not been involved in these discussions, so let me just see if they've got something that they can add on this.
Just as you do that, I can see Mr. Mr. Spencer, I think, is indicating that he may be able to assist.
Thank
yes,
you.
Oliver Spencer, BDB Pitmans for the applicant. I think to try to cut through some of the points here, sir, I think that the point here that we're trying to flag up in the Rep 10 document is that, of course, the Paynes Hill Residents Association and individual members of the association have made various points throughout the examination about the scheme generally, but those points do not necessarily relate to compulsory acquisition of land. And it's in that context that engagement has been described here.
Thank you, Mr. Spencer. So just for absolute clarity, as far as the various Paynes Hill residents are concerned, from the applicant's perspective, there is no ongoing or live compulsory acquisition or temporary possession objection under the legislation. Mr. Spencer or Mr. Humphreys, are you able to confirm yay or nay to that?
So I think there are, it depends. There are different, there are various different plots in relation to this. There are some plots, I believe, that may be owned by Paynes Hill residents, or that at least there may be some that are in temporary possession. So in relation to this, rather than us scrabbling around and trying to get what may be a not desperately complete answer for you, may I suggest that we just get a note that we can produce for you. You want to understand, firstly, what interest or what plots the Paynes Hill residents do or do not have, and I'm sure we can do that. And indeed, you can see in the table there for item 6 that there are a list of plots for Diana Barbanescu, both title acquisition, temporary possession, and permanent rights. And then I think, secondly, you want to understand the nature of the objections and the discussions we've had with those particular residents.
Yes, Mr. Humphreys, I think you've summed things up, because in terms of the representations that we've received from the Paynes Hill residents in various different forms, it is quite difficult for us to actually unpick, when we're just dealing exclusively with compulsory acquisition and or temporary possession matters, what the nature of their objection is. So I think the note that you're suggesting would definitely assist, and if we can have that by deadline 11, that would hopefully clarify things.
So certainly, I can see that that it's not all that easy to pull together from the various different places, and I'm sure that a note that deals with the Paynes Hill residents could be put together.
That sounds very good. Mr. Jones, have you got anything that you wish to add on Paynes Hill residents?
Nothing on Paynes Hill residents, no, Mr. Gould.
Thank you. Right, I'd now like to have a look at the temporary possession that concerns Nutbury Farm. Now, the examining authority has seen some correspondence from Nutbury Farm that goes back to, I think it was February. Unfortunately, that has not been recorded as a library document within the examination library yet. But essentially, what it set out, it's an email of about a page long, sets out a concern about the way negotiations are or are not going with the applicant. It also set out the likelihood of the owner of Nutbury Farm wishing to attend this hearing. They, as far as we understand, have been invited to the hearing, but have made no request to attend. The email that I'm referring to will be published at the next opportunity as an examination document. But I think it would assist, if you can, just to outline what the negotiations are that are going on with the owners of Nutbury Farm at the moment. As we understand it, they do have an agent, but their agent also doesn't seem to really engaged with the examining authority to provide any sort of written representation about what their side of the case is. So is there anybody from the applicant's team that can assist just in explaining what the Nutbury Farm position is at the moment?
Yes, so I'll start, and then if necessary, others can come in. I think that February submission, which appeared on the PIN's website on the 8th of June, was a representation from the Cocolios, and it, in its essence, it made 3 points. One, that negotiations had not taken place. Secondly, the viable access from Mr. Kokolios' land to the site and his proposed development, he says, would be impacted by the temporary works compound. And thirdly, that the temporary compound would interfere with the business of car boot sales. I can assure you that there has actually been quite a lot of contact between the Kokolios and their representatives and the valuation office agency. I think between about September last year and up to date, I've got a list of some 22 communications. Unfortunately, in the early period, a lot of those, as is not unusual, were negotiations about the fee levels for that Highways England would pay for the Kokolios' agents, and that unfortunately rather slowed things down. Our understanding is, but I of course mustn't speak for the Kokolios, is that but our understanding is that ultimately these objections amount to points which go to matters of compensation. But I will just invite either Mr. Pugh or Mr. Smith to comment as appropriate on this one. I think this one might be for Mr. Smith, so that's Graham Smith, sir. And I think Mr. Wade has also been sort of involved in all of this.
Thank you, sir. It's Graham Smith from the Valuation Office Agency. Yes, there have been negotiations from late last year.
Sorry, Mr. Smith, I'm finding it a little bit difficult to hear, so I suspect others might be. Are you able to get any closer to your microphone or turn it up a bit?
Is that any better?
Carry on, please.
I have had discussions with the Kokolios' agent late last year and into this year, and Mr. Humphreys correctly summarises that we believe that the objections are being overtaken by the ongoing discussions I'm having with the agent for Mr. Kokolios around the issue of compensation.
Thank you, Mr. Smith. Is there anything, Mr. Wade, that you wish to add to that? Or I suspect what I'm going to say, as was just offered in terms of Paynes Hill residents, that to help us understand, that's the examining authority, understand what the current position is, if we can just have a brief written note that sets out where you think you are at the moment, that might assist and mean that we don't have to spend too much longer with this particular. I think we will treat it as an objection, albeit that it's not yet picked up in your schedule. Mr. Wade?
Sir, it's Jonathan Wade, Highways England. There's not a great deal I can add. The contents of that email was certainly correct back in February, but we've moved on some considerable distance during the intervening weeks and months, meeting Mr. Kokolios and his agent on site and discussing a range of aspects to do with the project and what we were seeking to do on his property.
Thank you, Mr. Wade. I think a brief note just setting out where you think you are at the moment will assist us just to understand the position. Is that something the applicant is willing to do? Mr. Humphreys, I think you've popped up.
Yes, we can certainly do that. Sometimes there's a slight time lag on me pressing the button for unmute and it actually unmuting. So apologies for that. But yes, I'm sure we can produce a note for you on that.
Thank you. Whilst Mr. Gould is just composing his thoughts, I would just like to let everybody know that The email that was referred to has now been published in the examination library, and it's AS for additional submission. So it's AS/034.
Thank you, Mr. Jones. Apologies for any confusion. The last time I checked, it wasn't there, but that was a little while ago. But
so we believe it went up. That's how we were aware of it, and I assume that this is a note for D11, sir.
Yes, please. Right, then the only other site-specific.
Just before we move, we move on, Mr. Gould, I did have one question about Nutbury Farm, and that was just the area proposed for temporary possession. Has that changed at all, having regard to change 9 and the proposed change 9, which is the Wisley construction compound? Effectively, some activities that were going to take place in the Nutbury Farm site have now been decanted to the Wisley Airfield site. Has that changed the area of land required for TP at all?
So my understanding is that it hasn't, because change 9 was in effect a sort of a rearrangement of different activities. So I don't believe it has, but I'll gladly be corrected if I've misunderstood that point.
Mr. Wade.
Jonathan Wade for Highways England. So I'm not sure what was going on there. There's no change to the requirement to Nutbury Fruit Farm as a consequence of the Wisley Airfield. The Wisley Airfield site is a large site with some hard standing, which makes it more suitable for some activities. That's why we were seeking to be able to use the part of the airfield site in addition to the Nutbury Fruit Farm site, which is quite low lying.
Thank you, Mr. Wade. No further questions.
Right, thank you. I'm conscious that we're a little bit beyond the hour that we talked about for adjournments, but if people are feeling comfortable, we're not far from finishing this session, and because I've got one more site-specific question. I don't know whether Mr. Jones has any sites that he wishes to raise. Otherwise, we'll be heading into agenda item 5, which is a review of this session and the potential closure of this session. And looking at the time, that could well all be concluded by about 12:30. So it might be that we just crack on rather than going for an adjournment at this point. Are people content to proceed on that basis?
I am content, sir.
Anybody else that's listening in on the call, is everybody else happy to proceed that way? Well, let's put it another way. Is there anybody that isn't content to proceed that way? I hear silence, so I think that's how we'll carry on. Right, my last site-specific question really revolves around Elm Corner, where there are a few site-specific objections that have been made, particularly revolving around, I think it's plot 23-4 and the proposed turning head that's between Orchard Cottage and 2012. I don't think we need to bring the land plans up unless the applicant feels it's necessary just to talk around this point. But again, I'd just really like to get a feel for where negotiations are going. Is there, in effect, a compulsory acquisition and or a temporary possession objection that is still live and is not really resolved in the schedule that we talked about earlier? Mr. Humphreys or anybody else from your team?
Yes, I think I'll need to get someone else to comment on the detail of this particular one. I don't know whether
Looks like
either
Mr. Wade might be coming in.
Mr. Pierce or Mr. Wade. This.
So, Jonathan Wade from Highways England. There's been quite considerable dialogue between representatives of Elm Corner, and there are now monthly meetings taking place between ourselves. The particular issue over the turning head was a question from them as to why it couldn't be on the north side of the road rather than the south side of the road. And due to the SPA land on the north side, no, it can't be. We've explained that issue away, and I don't believe it continues to be an issue with the Elm Lane residents.
So I think if you do look in the compulsory acquisition schedule and you kind of just search on Elm Corner, it does throw up, where there are objections, and I think that sets out pretty much the latest position.
Thank you, Mr. Humphreys. Is it that the residents have recently got an agent acting on their behalf? And is that assisting things? Because it seemed in the early days of the examination that might not have been the case. Mr. Wade, you've got your hand up.
Yeah, I can answer that. Certainly they have appointed an agent comparatively recently, probably in the last 3 to 4 months. I think that was really to formalise matters. The agent, in fact, isn't present on the calls that we're holding with the Elm Lane residents, and they've formed a group between them, and they're fairly well represented. And certainly the agent is not present at those meetings.
So if in the CA schedule you were to look at item 5, I'm not suggesting it's brought up, but just for your note, which happens to be Aaron and Peter Young, but in that final right-hand column, it says on the 15th of April 2020, agents White and Sons engaged, and the applicant is now corresponding with the applicant's agent. And I think, in effect, that is an example of what Mr. Wade has just said.
Thank you. So I've got the schedule in hard form, and I can see that is. I think certainly from my perspective, I understand what the position is. Mr. Jones, is there anything that you feel you need to add or ask in respect to this particular set of objections?
No, I'm fine on these.
Okay, well, those were the 4 site-specific type objections that I'd identified that I felt that we needed to ask questions about. Mr. Jones, are there any other sites that you feel you'd like to ask any questions of? Otherwise, I think agenda item 4 is complete and we are into agenda item 5.
Nothing else from me. And so unless I hear anything from anybody else present, I'll move on into agenda item 5, which is review of issues and actions arising in next steps. So if I don't hear from anybody, no hands up, nobody wanting to say anything, in which case I'll go through the action points that I have from today's first session. Now, some of these are definite action points, and some of these are only action points if agreement isn't reached by the close or almost the close of the examination. So there's almost 2 timescales for this. Some we would definitely need, and some we may or we may not need. So in terms of the latter category, the may or may not need, would be I have a position statement on the situation with Affinity Water, the protective provisions regarding section 127 and 138. Again, only required if that isn't sorted before the close of the examination. Similar thing in terms of an update, position statements on the DEFRA Crown Land issue, if that matter isn't completed and consents aren't agreed. And those would both be for presumably the final deadline, which is the Friday, the 10th of July. And I would just take the opportunity now to say that we actually close on the 12th of July, which is a Sunday of all days. So just bear that in mind when making submissions, please. Clearly email's one thing, but if you're looking to post anything in, we're not going to get it on a Sunday. And clearly if we don't have it by the close, then we don't see it. And then again, if agreement isn't reached, I've got position statement on the negotiations with the San Domenico site. So those three are all position statements if agreements aren't arranged. And then in terms of things that we are going to need, and these are both by deadline 11, which is Friday the 3rd of July. Then I have a note regarding the plots and discussions with the Paynes Hill residents. And I have a note regarding the current situation with Nutbury Farm. Those are all I have. So 3 position statements that may or may not be needed and 2 notes for deadline 11 regarding Paynes Hill residents and Nutbury Farm. Have I missed anything? Did anybody have anything else that they'd noted down? No, I don't hear anybody. I can't see any hands up. So presumably that is all done. Just before I ask for any final comments from anybody, can we please have any post-hearing documents or any responses to actions by deadline 11, please? Friday the 3rd of July at the latest. We will publish the recording of today's hearing on our website as soon as practicable after the hearing, and that will be a video recording as well as an audio recording this time. And just before I close this session, is there anything that anybody wishes to say or raise in relation to the matters covered in this session only?
No, sir. On your action, sorry, I couldn't unmute quite fast enough, but it's a very minor thing that we were going to do anyway. But if you remember on the Crown Land Plans plot 2.27b, yes, which is incorrectly shown as Crown Land, we're going to correct that, but you may want to just record it so that in your own notes so that you can make sure it's done.
Thank you, Mr. Hamilton. Yes, I'd taken that one as read, but yes, that was for deadline 11, wasn't it? You were going to submit the amended plans.
I can't remember which deadline it's going to be, but it needs to be done before the end of the examination. It's a simple correction, and we'll make sure it is done.
Okay, thank you. I think when you said it at the time, I think you said deadline 11, but as long as you've definitely got it in by close of the examination.
Sorry, if I can just interject there, Mr. Gould. Mr. Humphreys and the absence team, I think that correction to the land plans does need to be made by deadline 11, just in case there's any issue that we spot and we have to come back to and say that's not quite right. Can you have another crack?
Yes, sir. Completely understood. Thank you.
Okay, well, if there's nothing else, first of all, I'd like to thank you all for your contributions to this session, the first in the new virtual world. Thank you for your help and for your patience with this new format. It's not perfect, but we're doing the best we can. I believe we've now covered all the items on this particular agenda for this session. And so we move on next to part 2, session 1, which is we put on the agenda not before 3 o'clock, but obviously because we've made good time on this one, it'll be the arrangements conference for that at 2:45 with a view to commencing at 3 o'clock. We had hoped, we haven't got Paynes Hill Park Trust representatives here today, but what we'd hoped to do is actually do one arrangements conference for both the guides and the Paynes Hill Park Trust, so that when we finished with the guide session, session 2 part 1, we can move seamlessly into session 2 part 2, and it saves having to do another arrangements conference, and B, it saves me having to go through this rather long spiel for a third time today. So I'm rather hoping we can do that, but because we don't have the Paynes Hill Park people in at the moment, we can't guarantee that, but I'm hoping that's going to be the case. But either way, we will certainly recommence yourselves 2:45 for the arrangements conference, and then 3 o'clock start for part 2 session 2 part 1, dealing with the Hazelwood campsite. So unless there's anything else, it's now 12:26. Once again, thank you all for your attendance for this session, and session 1 is now closed. Thank you very much. See those of you who are attending this afternoon. Thank you.
I think we can go now.